Hi, everyone, and welcome to our webinar, Trying Difficult Cases from Both Sides of the V. I'm Ryan Frome-Pizzulli, Staff Assistant for the Institute for Energy Law, which is an institute of the Center for American and International Law. Today's program is hosted by the Law School Outreach Subcommittee of IEL's Young Energy Professionals Practice Committee. This webinar is the fourth and final part of our four-part series of webinars designed for summer associates. If you missed a session, all sessions will be posted on our YouTube channel, and I believe 2 are already up there. I would like to thank IEL's online learning sponsor, Baker Bots. Its annual support of all of IEL's programs allows us to make this program free to IEL members and to law students. Our moderator today is Cristina Goulet. She is a litigation associate practicing in Kean Miller's offshore energy and casualty mass tort practice groups based in Houston, Texas. Presenting the plaintiff's perspective is Ron Franklin. Ron graduated from the University of Texas Law School in 1976 and started his career at Vinson & Elkins in Houston. He left V&E to start his own personal injury practice, and then after 30 years left to open the Houston office of McGuire Woods in 2009. He is a self-described dinosaur, his words, not mine, having tried over 100 civil cases to a final jury verdict in virtually every area of substantive law during his 50-year career. Presenting the defense perspective is Chuck Talley. He is a partner in the New Orleans office of Kean Miller and has been practicing for over 40 years. He is a litigator practicing in the firm's offshore energy and marine practice groups. Chuck has tried dozens of cases in state and federal courts in both Louisiana and Texas. I'll now turn it over to Ron and Chuck.
All right, good afternoon. I'm Chuck Talley. Ron and I were talking, and we're going to do things a little bit different, and that the defense is going to go first in this instance. So I'm going to lead off, and then Ron's going to follow, and hopefully we'll get some good banter going back and forth. When I was a young litigator and associate way back in the day, one of my mentors at one point told me, he said his words were, "It's all about the show." And, it kind of caught me by surprise because, we're taught in law school and when we're young bucks that, it's all about the facts and the law. You got to argue this, you got to have some great exhibits, you got to have demonstrative aids. We've got truth, justice in the American way. It's always going to prevail. You've got Lady Justice standing there. She's blindfolded, so everything's on a level playing field and all that. And this partner of mine basically said, you can throw all that out the window because the bottom line is, if it doesn't help the show, don't use it, because everything you do needs to be focused on what is the show, what is the presentation that you're giving to that judge or that jury in order to sell your side of the story. Now, that doesn't mean be unethical or not to lie, etc. But there are just bits and pieces that you want to change and to adapt your show. Now, from the defense side, you got to realize we start off with one foot in a hole. The trial starts, the first opening statement you're going to hear comes from the plaintiff, not the defense. So they hear that side of the story. And then we're from that point on, we're trying to do damage control. The first witness that gets on the stand is going to be put there by the plaintiff. And assuming Ron's doing his job, he's going to put a good witness up there that's going to start off and to tell his side of the story in a positive way. Take it one step further. Oh, if you have a personal injury case, you have somebody sitting right in front of the jury who is arguably injured, and there's a natural sympathy there as well that you have to fight against. To take it one step further, the plaintiff puts on his entire case. You talk about feeling like your case is going bad. Every defense lawyer feels that way at the end of the plaintiff's case, because everything you've heard up until then has been what the plaintiff wants to put on. Yes, we've had some cross-examination of witnesses and things like that, but it's been arguably good thing after good thing after good thing for the plaintiff. And so now we have to start to dig our way out of that hole. And, it comes down to the show, what's going to sell, what's going to dig us out of there. All right, what types of things affect the show? One big one is keep it simple. It's the old KISS theory, keep it simple, stupid. If it makes your case easier to believe, you don't get the judge or the jury lost in the process. If you have some complicated explanation that you need to be able to exculpate yourself, don't use it because it's not going to do you any good. Another thing is big, you have to relate to the jury. In most cases I've ever been in, the plaintiff is at a table sitting closest to the jury box. So there's just a natural, better connection there, sitting right there, particularly if it's a personal injury case, this injured person is sitting there. And, so you have to sit where you are at your table and you're hopefully making eye contact with the jury and, they're watching you to some perspective. When you speak, you need to look to them sometimes. In the old days when we used paper exhibits, Ronald can probably talk about this. It was always good to be able to walk up and hand each juror a copy of the exhibit. You had, some actual contact that you could make that, is made you more of a person. You could work that. Body language is part of that. You can't sit there looking mean and scruff and all that, and then all of a sudden turn on, Mr. Nice Guy when you get up to the podium. You have to kind of always display a good demeanor to where, you look like somebody the jury might actually like. And this applies to your witnesses too. Particularly if you got somebody sitting at your table, like your corporate representative or somebody else. My wife sat on a jury one time and she said that they were getting ready to basically zero this plaintiff who was claiming to have a back injury because he sat there all day in a chair and he didn't squirm or ever act like he was in any kind of discomfort. As it turns out, they settled the case, so they didn't get to do that. But she was like, we just didn't believe him. So, body language can have a big role. You don't want to over object. You may think, every question, because you're in law school, you've learned your evidence, all the different rules, and what violates the rules. So you want to get up and object. But if some judge is basically not leaning your way, if they don't see things as hearsay the way you see things as hearsay and the like, you need to back off a little bit. You don't want to look like you're beating up on someone. Particularly you don't want to appear to be picking on a witness. If you have somebody who has trouble conversing, or remembering things, if you beat up on them too much, next thing you know, you're kind of viewed as the bad guy. Another thing that affects the show is technology. In today's world, as I mentioned earlier, we don't use paper exhibits. We use everything's done electronic, and you submit it. And as a consequence, you want to make sure that you know how the court's electronic system works. That almost every court will give you an opportunity to get in the courthouse early, the week before, so that you understand how their machine works and how you go about presenting, presenting your exhibits. And you want to be able to do that seamlessly and flawlessly, so that it doesn't look like you're just fumbling. Then on that note, nowadays there's a service that's out there. It's called trial directors. These people are fantastic. They will take your exhibits. They'll take deposition transcripts that you have that you may want to use. They'll take the PowerPoint for your opening statement and things like that. And they will take control of it with you there. And they will help present that in a very professional way, particularly if you have a lot of exhibits, or if you're going to be using deposition transcripts and some things like that, they get get to be a little messy, and you want to, because now with depositions, a lot of them are by video, so you're going to show your video. Well, unless you want to become the technological assistant, it's much easier to turn those over to a trial director. So it's a great service that's out there when you start to try cases. Another big part of your show is credibility. I don't care what comes out of a witness's mouth. If he doesn't deliver it in a credible manner, it doesn't help the show. Unfortunately, there are just some people, they could tell you that the sun rose this morning, and just the way they are, you're not going to believe it. And there's other people who can sit there and they can tell you the sun didn't rise this morning, and they're just so credible, you would believe it. You've got Mother Teresa on the stand. She could be telling everything that she knows, and as truthful it is, but if she didn't have a credible appearance to her, a judge or a jury is probably not going to believe it. For this reason, you want to work with your witnesses ahead of time. You spend a lot of time with them so that when it comes time for the show, so that the show looks good. Think about the theater or a circus or anything like that. Those people look good because they practice, and you do that with your witnesses as well. When you look at what exhibits and witnesses you want to use to prove your case, you have to ask yourself, does that witness or does that exhibit really help the show? If it's just some minimal part or something that it's redundant to something else that was done, but it doesn't have much pizzazz to it, leave it out. It's you want to have that good appearance where it's clean, it's crisp, it moves, and you keep telling your story.
I have a quick question on that note. It sounds like that kind of goes back to your point of keeping it simple in the energy litigation context, where these, issues of liability can be really complex. What can the defense do to dumb down these issues? Is it the practice with the witnesses?
Now, one of the first things you have to do is simplify the facts, because particularly in the energy world, if you're trying some reservoir damage case or something like that, you're talking about something that's very complicated, just for people to understand who have been looking at it for years. And you have to get it to where some judge or some jury can understand it on their first go round. So you really have to leave out a bunch of the details with that get people lost, and you just have to simplify it so that then spills into your presentation. And a key person in all that is also your expert. You're going to call an expert, and you can't have him diving into mathematical formulas and other things that all of a sudden you've got a judge and jury with their eyes glossing over because you just lost them. So you have to really kind of dumb it down a little bit. And a good person to practice on is your spouse, because if your spouse hasn't heard about the case at all, it's like, all right, give me 10 minutes and see if you understand what I'm talking about. You need that kind of presentation. And one of the last kind of parts that get into the show, and that is how long the show lasts. Some courts don't put too many constraints on you on how long you can try your case and how long you can talk. And so you just keep going. I mean, we can all remember the times we went out for some speech or some presentation and we walked out saying that, that presenter could have made his point in half the amount of time. Well, it's that kind of way with a judge or a jury. I mean, particularly the jury, they're in from their day job and they're sitting there, And if you're just, you got them thinking they're watching paint dry, you're going to kind of lose them. And the party who has a little more pep in their step and a little more pizzazz to their presentation is going to come across as a little more credible. You want your opponent to look like the one that's been keeping them there for the extra day when they'd rather get done and move on and leave and go home. So the bottom line is, as I said at the beginning, it's all about the show. You gotta deliver a good product. It's almost a little theatrical. I hate to say that, but it is. It's not like we're just giving this this boring rendition of the law or the facts to some impersonal entity. No, you're talking to judges and juries, and you got to deliver your story.
Awesome. Thank you, Chuck. We can turn it to Ron now.
Thank you, Chuck. You can tell I'm the plaintiff's lawyer because I'm the one not wearing a tie. And I appreciate the introduction. I've been sitting here thinking a little bit about our audience today, which is really summer associates, lawyers about to become lawyers who want to be trial lawyers. And I want to give you some things to think about that are not going to turn you into the world's greatest trial lawyer. The truth is you probably won't be trying a case in the next 3 to 5 years, but you'll be in a position to maybe take some depositions and be an asset to whatever group, team, or partner you're working with. So I kind of have that in mind when I talk about some of the lessons that I've learned. I was blessed because I'm in Houston now. I grew up in Houston. I started my law practice in Houston in the 70s at a time when Houston, Texas was really the best place in the country to try cases. There were many, many very well-known trial lawyers, including Joe Jamale, Gus Coleus, Knox Nunley, many lawyers from the big firms when we were trying a lot of cases. And when I started at Vincent Elkins, I was blessed because I was trying a workers' compensation case, once a month. It was a 3 or 4 day case, and you go over and you pick a jury, you put on an orthopedic surgeon, you'd try a case and get a jury verdict. And young lawyers don't have the opportunity to do that these days. And after spending some time at Vincent Elkins, I went over and started my own personal injury practice until in 2009, I started at McGuire Woods, and very fortunate to be there. I bring that up because I've tried both plaintiffs and defense cases, many plaintiffs and defense cases. And I really have the exact same approach with both of them. I don't see a difference in the V, so to speak. And the reason I say that is because I view every case as the same. There are good guys and there's bad guys. There's right and there's wrong. You've got to be good and you've got to be right. That's it, every case. Doesn't matter how simple, how complex, how complicated, how long it lasts, or how short it is. Because at the end of the day, it's in my view that that's how juries decide cases. Every case. But for again, addressing the group that's here today, young lawyers or soon to be lawyers, you're in a very different world than Chuck and I grew up in. I went to the website. I was curious. The National Institute for Trial Advocacy, NITA. Many of you have heard about that, and a lot of firms think it's great to send young lawyers to NITA and learn these trial skills. And I had to really chuckle because I saw on their website, they say, quote, "We draw on cutting edge discoveries in linguistics, neuroscience, and sports psychology to give you the competitive edge the next time you stand up in court." And my view of that is seriously? Seriously? They're going to teach you to be a trial lawyer? And whatever the opposite of that is, that's what I am. That's what I've learned over my 50 years doing this. So what I want to discuss with you in the next, few minutes is, in my view, how do you persuade jurors? How do you really persuade people of the truth of your position? And second, how do you convince them that by doing what you ask, they're rendering a just verdict? Because that's what every case is about. So, having done this, as I say, for almost 50 years, I'll tell you, in my view, what is the secret to being a great trial lawyer? What was the secret of the great trial lawyers that I watched growing up in Houston? And to me, the answer to that is by moving to another world. You have to move to another world. You have to move to a world where the jury lives, not where you are now. A world with real people, real emotions, real common sense. And the way you do that, to move to a jury's world, is to recognize, first of all, that you can't trick them. You can't trick them by having fancy graphics. You can't trick them by having a super duper qualified expert. You can't trick them at all. And the way you express that belief is that you must be a real human being in standing up in front of a jury, a real human being. Now, I'll give you an example. Some of you may have already been told in your learning that, here's an example of a closing argument. Ladies and gentlemen, I just want to thank you for the time that you spent the last 2 weeks listening to this case. I saw that you were all very connected, and I want to thank you for that. Plus, we recognize it's taken time from your homes and your houses to be with us. And that's part of the American system, and we're really grateful for that. If, by the way, I've done anything that upsets you during the case, please don't hold that against my client, hold that against me. Now, that's an argument that has been around for a million years, that lawyers have passed on one to another. And my suggestion is that you are real. And so I'm going to give you the first 30 or 45 seconds of the last final argument I made. As follows. Ladies and gentlemen, when I first started doing this, you could actually go to books and read books on like what color tie to wear when you make a jury argument. You can go to courses and they tell you, make sure you don't wear the same shoes 2 days in a row because the jury might be offended or something. And by doing that, along with my stellar personality, they try to convince you that you can, hypnotize a jury into doing what you want. And to tell you the truth, ladies and gentlemen, I tried that. I tried that for a few years, and it never worked. Not one time. I was never able to hypnotize the jury into doing something. And then I realized, in fact, I took time to do it today. I added up all your ages, and the 12 of you have 347 years, combined years of experience, of common sense. And what I know is I can't fool you. And what I believe is you've probably already decided this case based on that. I think I know what you've decided, but I'm not here today to convince you. I'm here to maybe remind you of that. Now, that's two very different styles. And the second one is totally true. And so how do you become a real human being? How do you become a real human being, whether it's in, and I'm going to say this, in a deposition, or whether or not it's in a trial? What does that really mean? And you might be surprised or will be surprised to hear me say is, because it took me a long time to figure this out, but again, I say it's the secret. First of all, forget everything you learned in law school. Don't be a lawyer. Don't analyze a case like a lawyer. Don't think like a lawyer. Don't talk like a lawyer. Don't be a lawyer. Be a person. Be a person. Look at your case and think, what is going to motivate a jury in this case? So don't be a lawyer, be a person, and be your authentic self. Be your authentic self and tell the jury the truth. Tell the jury the truth, because they will find it with or without you. What do I mean by that? I mean, if there's a fact in your case that you're afraid of, and I know Chuck would agree with this, if you're afraid of a fact in the case, tell them. Tell them about it. And tell them why you're afraid. Tell them why you think it doesn't ultimately matter in the outcome of the case. And, you know, one quick war story, some years ago when I was doing just personal injury work, and for those of you in Houston, you'll appreciate this, I had a personal injury case in College Station where Texas A&M was, and I drove into the town the night before the trial, and there was a big banner, "Welcome National Rifle Association," the most conservative community, you know, around here. And I had a case involving an automobile accident. And in fact, it's worse than that. My client was suing a member of the Corps, an Aggie. And this was also at a time when, if you read anything or kept up with anything, it was all about Citizens Against Lawsuit Abuse, you know, these damn personal injury lawyers. And so I'm pulling into the College Station the night before thinking, what am I going to do about this? And I was very afraid. So what do you do with that? Ask yourself that question right now. What do you do with that? Do you just kind of hide it and hope for the best? And so when I picked a jury, in that case the next morning, the very first question, I'm not exaggerating, the very first question I asked, I held my hand up and I said, there were 60 jurors. Ladies and gentlemen, raise your hand if you really hate lawyers. I mean, really hate them. Not just any lawyers, but ambulance chasers. Come on, I know you do. Come on, a little bit higher, a little bit higher. And so there's two ways to react to that. It's like, number one, oh no, 20 people in the panel have raised their hand. What am I going to do? Or the other way to react is, thank you so much. Now I know what I got to deal with. And so I had the people raising their hands, and I said, now put your hands. And I said, you know, we all hate lawyers so much. Let me just ask this question. Has anybody here ever hired a lawyer for any reason? And this guy raised his hand. Well, you, Mr. Smith, you hired him. What for? Well, my partner in my business, he messed with me and cheated me. And so you had to hire a lawyer? Oh, no. Well, but, you know, and then I said, is anybody on the panel going to hold it against Mr. Smith because he hired a lawyer? I mean, if you're on the jury with him, is that okay? Are you sure? Anybody else? Miss Jones, well, I was in a divorce. It really was, I couldn't work it. You get the idea. And by the end of the time, after that, working that issue, I said, well, you know, my client, Johnny Jones, he had to hire a lawyer. And that's why I'm here today. Is anybody going to hold him against that? So that's an example of being real, confronting the issue, and recognizing the problems, you know, that you have. So number one, to win a case, you've got to be human. You got to be personal. You got to not act like a lawyer. And the second thing I would add to that is you must passionately believe in your case. Passionately believe in your case. Do you really care? And I don't care if it's a personal injury case involving a brain damaged baby. I don't really care if it's some complicated antitrust case. I don't care whether it's an energy case. You must care. You must passionately believe in it. And if you don't, you need to find a way to believe in it. because a jury is going to understand that. Do you really care if your client goes bankrupt? Do you really care if the jury gets it right? If I lose this case, am I going to be disappointed or am I going to die? You better really care because the jury is going to understand that. And so whatever the case is, you've got to have something to motivate you. Some of you may chuckle at this. Some of the young lawyers I work with do too. I cry at every case. I cry at every case. It is not planned. It's not because I think it's a good practice. It's because by the time we get to a final argument, I am so tired, number one, so exhausted, number two, and number three, so believe that I just get emotional with it. You can't fake that. And if you can, don't. But if you feel that way, if you feel that strongly about doing what's right, it should make a difference. So you've got to be real. If you're a real human being, if you're passionate about what you do, you'll be persuasive. And in terms of what the story is, the question about, somebody asked a question about how do you keep it simple, stupid? That's true. But to me, I tell the young lawyers that I work with, and this is, and I'm not overstating this is the most difficult thing to do in any case, and that is to describe it in a way that tells the whole story in 2 or 3 sentences, not 6 sentences, not a paragraph, but 2 or 3 sentences. And that sentence has to include that you're right, you're good, and why you should win. Now, how do you do that? How do you do that in a complex case? Well, it takes a lot of work and a lot of thought. Forgive me another war story. I had a defense case for Devon Energy, classic energy case. What happened in that case? Well, a landman for Devon drilled a well, in the wrong location. He missed it by 1/4 of a mile and drilled right through an operating mine. Not good, right? So what was this case about? How would you describe what this case was about the first time you would stand up to defend this case? I'll tell you what it wasn't about. It wasn't anything to do about drilling a well in the wrong location. That's not what the case was about. The case was about whether or not you were going to destroy a landman's career who'd been with the company for 40 years. That's what the case was about. So don't get overwhelmed by the regulations and whatever the complexities is of an energy law case or an antitrust case or an IP case or all these technical things, because I'll say it again, every case is the same. There's good guys, there's bad guys, there's right and there's wrong, and you need to characterize it like that. And once you do, convince yourself that you're right, be passionate about it, be who you are. Now, I'll just conclude by saying, because as I said, most of you are going to be taking a lot more depositions than you're going to be trying cases. But the same thing, the same rules, the same thought, the same passion, the same understanding applies in depositions. For those of you that have sat through depositions already or will see one, it's always the same. State your name for the record, please. You understand that you're under oath. If I ask you a question you don't understand, please may ask me to repeat it. If you answer it, can we assume you gave the best and most honest answer? If you need to, why are you asking him all that stuff? Why are you asking him all that stuff? He knows he's under oath. You even know his name because the record report is gonna write it down. Start in a different way. Start doing something fun. Do something real. Mr. Smith, why did you do this? Why did you take this action in this case? Would you explain that to me, please? What? You don't see many depositions like that unless you've seen one. And then it makes you think. And that causes you not to be a lawyer, forget everything you learned in law school, and to be a real person. So that's it for me in a nutshell. It's not National Institute of Trial Advocacy. It may not even be the right thing for any of you, but it's the lessons that I've learned and have had some success by following that. So I wish I could see you. I can't, but I wish you the best in your careers. And my last comment again is, if you're going to get in this business, be passionate about it, because jurors get it right. I'm telling you right now, jurors get it right. I've tried to hypnotize them, never worked. Never worked. Thank you.
You know, a couple of things Ron said, sparked some thoughts with me. One of the big ones is the lack of trial experience that you're going to have. To be honest, I mean, I think Ron would agree with me. The number of cases we tried in the first 20 years of our career compared to the number of cases we've tried in the last 20 years of our career are woefully different. Courts today are trying to force you to go to settlement conferences and mediations and to do everything they can to keep you from actually trying your case. So the amount of actual trial experience that you're going to get is going to be limited, and you need to use it for all that it's worth. And that even applies to oral argument on motions. And you have a lot of courts that just won't give you the oral argument. When I was young, we used to head off to federal court every Wednesday morning with a couple of files under your arm because you had a couple of discovery motions you had to go argue. And you learned to stand there and take the shots from the judge and keep swinging. So you had that part. All right, but on a humorous anecdote, Ron mentions that he's the plaintiff attorney because he's not the one wearing a suit. We had a case up in Madisonville, Texas one time, and we show up that weekend to get ready for trial. There was a bunch of defense firms, and trial didn't start till Tuesday or Wednesday. But in the Monday or Tuesday morning newspaper, it basically said that the dark suits are in town. And you could just kind of tell there was a demeanor associated with, the defense lawyers. We're all showing up in our standard issue dark suit, possibly a red tie, etc. Whereas it made me realize that the plaintiff attorney that was in that case, I never saw him in a suit. He was always, best case, he was wearing a sport coat. And ever since then, I ramped up my wardrobe to include a line of sport coats so that I could come in more casual, because it ties into what Ron said. You want them to see you as a person, that you want them to see you. And you throw on that standard issue lawyer uniform, and sometimes it throws up a little roadblock.
I'll tell you, thanks, Chuck. I'll add to that war story that we'll give our group a little thought problem. Let's say you're at a deposition and it's a federal court case in Houston, but you're at a deposition in Boston and you're bringing a case against General Motors. It's happened to me. And you show up for video deposition, and the defense lawyer for General Motors has set up the videotape operator and all this. And you start the deposition, and I'm sitting there and I'm dressed like I am now in a sports shirt. And he says, because I have been too aggressive in other depositions, he's decided to have a camera both on me and the witness. Okay, and you're standing there. The witness is there. You're getting ready to take the deposition, and there's a videographer. And of course, I don't want the camera on me, but he says I've got it set up. Now, for all you law students and young associates, tell me where it is in federal procedure that answers the question whether or not he's entitled to do that. And I'm going to suggest to you that you're not going to find anything. So then we're going to get back to the main, one of the main comments on my presentation today was, don't be a lawyer. So what do you do? And I said to the defense lawyer, so I'm not going to go forward like that. And he says, we'll just call the judge. I said, fine, call the judge. So we got the judge on the phone. It was Sim Lake, highly respected federal judge in Houston. And the defense lawyer went on and on saying how aggressive I'd been, and he wants to make sure that the jury sees my facial expressions and all this kind of stuff. So what was my argument? It wasn't in the federal rules of procedure. My argument was, Judge, I would have had no objection at all to him having a camera on me if he told me beforehand so I could have worn a suit. And that won the day. Nothing to do with the rules, just being a human being, thinking about the situation. And then I'll add one thing and kick it back to you, Chuck, because you made a very good point that these young people are going to be more involved in taking depositions and attending depositions. And so I'll give you one other thought, and I heard somewhere somebody said that Baker and Botts had something to do with sponsoring this. Of course, Baker and Botts, highly respected, wonderful firm in Houston. Have a lot of friends there over the years. And they had a wonderful defense lawyer named Walter Workman. He was just the dean of the defense bar. And in spending time with him and learning about cases and trying cases, he told me something that I've never forgotten that will actually, I think, help all the young lawyers listening to this who get involved in depositions, because it's something that you can do for your immediate supervisors. And that is, how do you prepare for a deposition? And again, think about the real world. Let's say you have a very important case, doesn't matter what kind, and a very important witness is getting ready to get deposed. And let's say it's a business case. So what's going to happen is the other side is going to spend hours getting this person ready for the deposition. We call it woodshedding. Take them out in the woodshed, get them ready. And these days, they're even more aggressive in big cases. They'll actually take a corporate witness, say, and put him on videotape and practice and let him watch, see how he's doing. He might even bring in some specially group to make sure he looks and sounds good, all that kind of stuff. So you're getting ready to depose this person that spent hours and hours getting ready for the deposition. And so you're a young lawyer and you're helping your team member or partner get ready for the deposition. How can you really help them? And I'm going to give you the answer, but it's a hard one to do. It's just like describing the case. Find some material part of the case, find something that's important in the case that nobody's really thought about, that you're pretty confident the witness has not been woodshedded about, is not prepared for. If that sounds hard, it is. It's really hard. But I have won cases because I would spend literally days thinking, what issue is out there that they've missed, that even I've missed so far, that he's not going to be ready for, that could make a material difference in this case. And I could give you an example, but I won't. But that just requires thinking about the case. And one of the things I hate about doing defense work and hourly billing is, you put in 0.25 of an hour and you can't just put thinking about the case, because your client's going to say, well, what do you mean thinking? What does that mean? I need to know that you were editing some motion. The truth is, if you put down thinking for 2 hours, that's really much more productive. in terms of winning the case. Because in the deposition example I gave, if you think about what is an important issue that the other side's missed that I can explore with them, that's something that your team member or partner that you're working with, you come up with something like that, he's going to go, that's pretty good. That's interesting. Maybe I'll try that. That's an example of, thinking like a lawyer and coming up with something. So that was something that Walter Workman taught me that I've carried through my whole career. And you can't always do it, but when you can, it's very, very helpful.
Talking about depositions, given the fact that so many cases don't go to trial anymore, you're literally trying your case at the deposition. It used to be more of a little fact-finding mission. You just wanted to get some information, make sure some witness wasn't going to, reveal something at trial that might kill you. But nowadays, the information gained, how that witness performs, etc., goes a long part when you get down to mediation or settlement conference. What is going to be the impact? How does the other side see their case versus your case on down the line? So, more effort needs to be put into it on a variety of reasons. That's why, for example, we videotape a lot of depositions now so that we have them, we can see the witness live, we can hand that to our client. The other side can do the same thing, and they can see that their guy just doesn't look credible. We have a problem with this witness. And so, as Ron says, you definitely want to put some effort into a deposition. And on the lines of what Ron said, I learned a very valuable lesson from a plaintiff lawyer named Ernie Cannon over in Texas about 25 years ago. We had a complicated drilling rig collapse case, and there were two defendants. I was one of them, and the plaintiff, and Ernie had the plaintiff, and Ernie was busy. Whatever this expert witness was, he was going to testify that day. And Ernie just said, y'all go ahead and get started without me. I'll maybe be back to ask a few questions. And, so we defense lawyers, we start going through the litany of questions we have and all the facts and formulas and details and all this other fun, complicated stuff. And at one point, Ernie comes back in. He's like, guys, I'm busy. Can I just ask a few questions? And we're like, sure, go ahead. And he asked like 4 questions, and he obviously had done his homework. They were calculated. It was like he literally just stuck his hand into our respective chest, pulled our hearts out, threw them on the ground and stomped on them. And he's like, thank you very much. It was just, but there's an example of how, he used a deposition to help further his case, because by doing that, we defendants knew that we had a problem.
Well, Ernie Cannon was a master at doing that. And again, that's back when, there were a lot of trial lawyers like that, in Houston. And I was just blessed to grow up with them and be around them and learn those lessons. I could, go on for hours about war stories, but, these people want some advice how to make them better lawyers from where they are today.
Well, you talked about earlier about trying to make the jury see you as a person. A trick that Ernie used to use that he shouldn't have been able to get away with it, but let's just say he knew the judge very well, where apparently after his opening statement, the defense lawyer would get up, he would actually walk out of the courtroom. He'd go to the coffee shop they had in the courthouse. He'd get 2 cups of coffee. He'd come back in. He would drop one off at the judge's bench and then go sit down. And on the one hand, the jury's sitting there going, what a nice guy. He's bringing the judge a cup of coffee. Not to mention, it was horrifically distracting if you're the defense lawyer trying to deliver your opening statement and this is going on. But Ernie could get away with it.
Thank you, Ron and Chuck, so much for your time. We really appreciate it.